Good morning, everyone.
Good morning.
Good morning, Judge Rovner.
Good morning. Good morning, Judge Brennan. Good morning, Judge Laney.
Good morning, Judge Rovner.
Judge Rovner, you're not missing warm weather, just so you know.
It's 3 degrees here and we have no heat.
Oh, no. Well, I think you've
Yeah.
got us beat. Well, we're here today for oral arguments. We're going to begin with case number 1. This is Appeal 24-1534, United States versus Carbajal Flores, and we'll begin, Ms. Steindorf, with you.
May it please the court, Maggie Steindorf on behalf of the United States. The district court erred when it determined that section 922G5A is unconstitutional as applied to this defendant because first, there should be no as-applied challenges to 922G5, only facial challenges, which the district court properly upheld. And second, even if as-applied challenges are allowed, there is no question that 922G5 is constitutional as to this defendant. Here, specifically, the district court erred when it found defendant was nonviolent, when in fact the defendant shot a firearm 7 times at a passing car without provocation and tried to shoot at a second passing car shortly thereafter.
Ms. Steindorf, is there anything about the Supreme Court's decisions in Bruin or Rahimi that undermine this court's conclusion in Meza Rodriguez that some illegal aliens can fall within the plain text of the people?
I think that Bruin and Rahimi again emphasize that the Second Amendment right belongs to law-abiding citizens, repeatedly referred to the right as belonging to citizens or Americans.
Meza Rodriguez did engage, though, with the Second Amendment's text, correct?
It did, but in Meza Rodriguez, the court referred to the Supreme Court's references in Heller and McDonald as passing references. I think with the addition we have now here of Bruin and Rahimi, again referring to the right as belonging to citizens or Americans, that changes the lens through which we look at the text.
Well, you agree, I take it, that we would not have to revisit our holding in Meza Rodriguez in the event that we conclude that 922G5A survives the Bruin inquiry.
That's correct. This court could conclude that 922G5A survives based on the history and tradition of disarming. Here the government argues disarming untrustworthy adherents to the law and those outside of the political community. The court could, within its precedents, find that non-citizens are part of the people and move on to step 2 of the Bruin and Rahimi inquiry.
If we focus on the people, how does the Supreme Court's opinion and Vertigo Cures impact our analysis? There, I know the court was looking at the Fourth Amendment, but it defined and talked about people in terms of having a connection with the country, having a connection with the community. It did not talk about people in terms of citizens or Americans.
Yes, it did refer to those who are part of the political community or national community, just as Heller did in referring to the people as members of the political community. I think the distinction that we can make here would be the scope of the political community as we understand those individuals who have Second Amendment rights.
But that's my question, I guess. How, given the language from the Supreme Court in that opinion, how could we conclude that the people in the Second Amendment only pertains to United States citizens, because that case was much broader and still remains good law?
I take your point that the people, for purposes of the Fourth Amendment, may include certain non-citizens. And I also take the point that the Fourth Amendment, the Second Amendment, First Amendment all use the term the people. I would also argue that the term the people appears in the Ninth Amendment and the Tenth Amendment. And certainly in the Tenth Amendment, we understand it to mean only the rights that are left for citizens here.
So is it the government's position that the people has a different meaning across the First, Second, and Fourth Amendments?
Yes, that the scope of the... I would say that the meaning of the people is members of the political community, but who are members of that political community for purposes of each amendment differs. That would be the government's position.
Just so it's clear, we're only talking here about G5A, not G5B, correct?
That's correct, Your Honor.
You know, you criticized Judge Coleman's person-specific risk assessment. But if we were to conclude that the Second Amendment does not permit the government to ban possession by any and all undocumented immigrants, might it still, do you think, be possible to distinguish between aliens with a criminal record and those without such a record, or aliens with a history of violent crimes and those with only nonviolent criminal histories? What are your thoughts?
It's the government's position that there's no proper as-applied framework, specifically within the context of Section G5A, because legislatures historically categorically disarm groups of people that would not abide by the laws of the community or were outside of that community. And so, especially within this context where there's no dispute that the defendant is a non-citizen unlawfully in the country, because he falls within the category and because Congress has categorically disarmed the category, the government's position that there's no proper as-applied framework here.
In the second step of Bruin, we're to discern the how and the why for purposes of determining whether there's a historical analog. Is it fair to characterize the why as a lack of allegiance to the sovereign?
I think the why could be characterized in that way. Are you speaking of the historical laws?
I am.
That certainly is the why of the loyalty laws specifically.
What about if the same law, though, is attempted to be utilized, say, in a G1 context, where we're talking about a dangerousness analysis versus a allegiance analysis? Does that present a problem?
I think that's where Rahimi teaches us that we're looking for principles of the laws. And so by the government proffering the loyalty laws, I take your question to be in both the G1 context and the G5 context. There is the common thread here of felons not abiding by the law and those unlawfully in the country, also, not authorized to be in the country. So because Rahimi teaches us to look at the principles of the historical tradition, certainly both can be proper analogs in both circumstances.
Thank you.
And historically, we are, I take it, it's the tradition of barring firearms possession by those individuals who have not demonstrated trustworthiness or loyalty to the government.
Yes, Your Honor, that is one of the government proffered kind of two historical traditions. One of them is, most evidenced by the loyalty laws, those that will not, that are untrustworthy adherents to the law.
Is it the government's position that G5 is a permanent disarmament? And if so, how is that historically justified? Given many of the laws that you've identified, there was always a way to restore your rights.
It is not the government's position that G5 is a permanent ban. The government has argued here that the conditions, being a non-citizen and being here unlawfully in the country, those are not permanent conditions, as there are pathways to lawful citizenship. But I would, I think the second part of the question here, as to specifically loyalty laws, you mentioned there are exceptions to regaining your arms. Here, I think the equivalent in the Section G5 context is the lawful pathway to citizenship.
And would it have to be lawful pathway to citizenship or lawful pathway to being in this country?
Excuse me, it would be lawful status.
If we use some of the same laws, though, I'm getting back to the G1, G5 question. If we use some of the same laws with regard to the Y component on the second step, is that going to backdoor us right back into an as-applied for this type of statute? To build out the question a bit more, the status concept of being a felon, a convicted felon, can have a broader variety than, say, the status concept of being an undocumented citizen.
And I think that would be the government's argument is here G5 is really only limited to people who are unlawfully in the non-citizens who are unlawfully in the country. It does not apply to all non-citizens, as you know. Perhaps you could make the analogy to the category of the felon. And so here, especially, I think categorically, it's appropriate, and the historical tradition supports being able to disarm that category of individuals. If there are no further questions, the government would request to reserve the remaining time for rebuttal.
That's fine. Thank you, Ms. Steindorf.
Thank you.
Mr. Briskman will now move to you for argument on behalf of the appellee.
Thank you. Good morning, Your Honors. May it please the Court. My name is Jacob Briskman, and I represent Rebuttal Carbajal Flores. This court in Mesa Rodriguez correctly held that undocumented folks can be part of the people, and nothing in Bruin or Rahimi takes away from that conclusion. The court below was correct in ruling the statute is unconstitutional as applied to my client, but the court below was incorrect to reject our facial challenge. Turning to the as applied. The test articulated in Mesa Rodriguez is the people refers to a class of persons who are part of a national community or who have developed sufficient connection with this country to be considered part of that community. My client easily passes this test. Father to U.S. citizen kids, husband to a U.S. citizen wife, attending public schools in Chicago starting at the age of 10, he is part of the people. The government wants the test to be political community closely associated with U.S. citizenship and the electorate. They do this by selectively choosing descriptive rather than prescriptive phrases from Heller, Bruin, and Rahimi. But
Mr. Briskman, before you go too much further, can I just clarify, are you appealing and challenging both the facial and as applies, or are you focused on as applied?
Well, certainly we want
I know you're doing as applied. Are you also appealing the facial determination?
Yes.
Or I guess the government has appealed, but are you arguing that 922 G5 is facially unconstitutional?
Yes, we are.
So is it your position then that all unauthorized aliens are among the people?
Well, the way that the Supreme Court has determined whether undocumented folks have constitutional protections is if they've come within the territory of the United States and they've developed substantial connection.
So what about those who do not have substantial connections? Is it your position that they would nonetheless be part of the people under the Second Amendment?
Well, certainly they can prove to be part of the people if they do develop substantial connection.
But that's not the question. It's a little bit different. If somebody just comes across the border, has no family here, no connections here, and when he crosses the border, he has a firearm, he's an undocumented alien, is he part of the people?
Your Honor, there would have to be a deeper inquiry into
I've
his
given you all the facts. There's no connection. He crosses for the first time ever, crosses the border illegally. He's not here legally. He's undocumented, hasn't started any kind of citizenship process. Is it your position that he would be part of the people for the Second Amendment?
Well, I think Verdugo requires a little bit more in terms of more connection to the country.
Okay, so you would agree that he is not part of the people if he has no connection to the country? I know you're resisting answering that, and I know why, because if there are circumstances where an unauthorized immigrant is not part of the people, then how can the law be facially unconstitutional?
Because we have this other inquiry from Bruin, talking about.
But it's a two-step. If you fail at the first step, you don't get to the second step. So if there are factual scenarios where someone would not fall within the text of the Second Amendment to obtain protection under the Second Amendment, then under Bruin, there's no Second Amendment right.
Well, we think the first step of Bruin is that if the plain text of the Second Amendment covers an individual's conduct. So the first step we talk about.
But that's not what the people is about.
The people, certainly.
That's defining a class of individuals. And if you fall outside of the people and don't have the Second Amendment protection, if there are some individuals who fall outside of the people, then it can't be facially unconstitutional.
Well, we think that Bruin's first step talks about the conduct of an individual. And we think that the plain text of the Second Amendment can cover the conduct of an individual that's not part of the people. And then we move to.
So you think even if you're not part of the people, that the Second Amendment protects, that you could still get Second Amendment protection? I think that's counter to what the Supreme Court has said.
Well, we think that needs to be an historical analog as to the why and the how.
That's
the
the second
second
step.
step.
She's on the first step.
In terms of there are certain individuals who can come in within the country and not be part of the people.
Okay.
Mr. Briskman, tell me this. Is it at all workable for courts to engage in the sort of person-specific constitutional inquiry that Judge Coleman conducted with respect to Mr. Carbajal Flores? Isn't the inevitable result just going to be a crazy quilt of fact-specific and potentially inconsistent holdings?
Well, the judge at the district court was trying to hit a moving target here. In terms of this court has not articulated a test of who among the people can be disarmed. The judge took a reasonable view of the facts, taking into account the night of the arrest, all of the circumstances surrounding the arrest, as well as my client's pre- and post-arrest history. So if this court were to articulate a test, certainly we would be in agreement if this court could remand it for an evidentiary hearing, so the district court could apply the test in the first instance.
How can, I'm sorry, go ahead, Judge Rovner.
No. Are you going to follow up on that question?
Yeah, go ahead, you follow up, and then I'll follow up on you.
No, go ahead. Go ahead.
How can a trial judge in a criminal case under Federal Rule of Criminal Procedure 12, hold an evidentiary hearing where she would be making a determination of something directly relevant to guilt or innocence? Here it would be the self-defense. I don't see how a district court has the authority to do that.
Well, we could think that the court could take an all things considered approach in terms of whether he's a dangerous person, taking into account all of his history, taking into account his.
Why does dangerousness matter under G5?
Well, we think dangerousness matters because that's what basically the court in Rahimi talked about, whether someone
That wasn't a G5, so is it your argument that anytime you assess or have an as-applied challenge in the 922G context, you have to look at dangerousness?
Certainly. We think that there are two tests. There's the test first for who is a member of the people, and then there's a test for who among the people can be disarmed. And we think that the court here did take an all things considered approach talking about my client's history. And these in the court.
Yeah. Even accepting that his criminal history was nonviolent, couldn't one argue that the nature of some of his prior offenses, including, reckless conduct, obstructing identification, demonstrate that he was not a trustworthy candidate for gun possession? And in any event, was it really correct, do you think, to say that the circumstances of the possession of the gun on the night of the arrest were nonviolent? I mean, firing a gun in public at passing cars, even if the shots were meant as a warning, doesn't strike me as nonviolent. And we have certainly seen enough of this sort of thing where innocent people are literally mowed down.
The district court took a look at this. The district court had the full video in front of the court and took a look at all the circumstances surrounding that night. And stripping people of Second Amendment rights because of a criminal history or because they are not responsible are not reasons supported by case law, as Rahimi has shown. I think it's important here to contrast my client's background with that of Mr. Rahimi, which the Supreme Court took pains in saying that 922G8 was constitutional as applied to him because of its limited duration. Mr. Rahimi was found dragging the mother of his child to a car, causing her to hit her head on a dashboard, and then firing a gun as she tried to escape, coupled with a series of other incidents involving shooting and threatening other people with a firearm. And my client's case, these were not random shots. He's contended since the beginning that these were warning shots at a specific vehicle perceived as a threat, after the police had come by telling the neighborhood watch to arm themselves. It's our position that 922G5 is unconstitutional as applied to my client.
Does it make any difference whatsoever that this was not his neighborhood?
Well, while he was living in Cicero during that period, he went to grammar school in Little Village. He lived in Little Village most of his life, and he continues to live in Little Village now. This idea that it was not his neighborhood is not taking all of his history into account. While he wasn't living in Little Village at that specific time, that's where he's from, and that's where he continues to live now. In terms of the government's test, the government's test is not supported in terms of who is a member of the people, is not supported by case law. In terms of, as we mentioned, the Supreme Court has decided that undocumented folks have First Amendment protections, Fourth Amendment protections, Fifth Amendment protections when they have come within the United States and developed substantial ties. And yes, my client does have criminal convictions, but the nature of his criminal convictions were looked at by the district court, and they were not violent in nature. I mean, these reckless conduct misdemeanor convictions, possession of cannabis, driving on a suspended license, and obstruction identification are not reasons for someone to be stripped of their Second Amendment rights.
Can you just tell me what his sentencing exposure would be if we were to reverse the dismissal of the indictment? If you looked at what the likely guidelines range might be?
I think it was this is a level 14, I believe. So I believe it's in the 18-month range with no other extenuating circumstances. Just the 922G5, I believe, is a level 14.
Thank you.
And we just don't think that there is a 922G5, while certain undocumented folks who come within the country may not be part of the people. We just don't think 922G5 has a historical analog as to the why or the how. I mean, this is, Your Honor talked about, this is a total ban on undocumented folks with no exceptions whatsoever. And all of the laws cited to by the government all had an individualized mechanism for the application for relief, whether it was taking an oath.
Why wouldn't becoming a citizen or starting the process to be here legally be that exception here, or that out for the individuals?
Well, the process, this is where I think the amici and the government get it wrong. It's not that just someone can say, I want to be a citizen and then swear allegiance or start an application.
There's a process, but there's still a method for it.
Not for everybody. Not for everybody, there's not. There are statutory caps that take decades many times for people to become residents. And also there are things called permanent bars that bar people permanently from ever becoming residents. So this in fact is a permanent ban for many folks in this country. And it certainly is a total ban. And we don't see an historical analog that bans people with no exception whatsoever. Whether, as we were discussing, whether it's a loyalty oath, getting special permission from a master, or in the context of self-defense, there are outs in every one of the laws the government cites. And that's one of the things that the surety laws in Rahimi that were approved. The surety laws in Rahimi gave room for someone to, even who was found to be dangerous, to have an exception for self-defense. So in terms of the why, and this court in Beavis has observed that the broader the restriction, the closer the analogical fit must be. And here, this is the broadest restriction as you can get. And there's not a close, and so therefore this court should require a very close analogical fit. And here, there just simply is not in terms of the how. In terms of the how, this is a total, and in many cases for many folks, it's a permanent ban. And in terms of the why, the government justifies based on the comparable justifications the government points to are based on horribly discriminatory laws that this court should not use as a measuring stick when defining the right. And also, this court has determined my client in Mesa is part of the people, can be part of the people, and the laws the government cites to simply are not folks who were determined to be part of the people.
Thank you, Mr. Briskman.
Thank you, Your Honor.
Ms. Steindorf, we'll go back to you now for a rebuttal argument.
Even under the district court's version of an as-applied test, 922G5 is constitutional as applied to this defendant. Here specifically, the district court erred when it found defendant was nonviolent when, as we've discussed, he in fact shot a firearm 7 times at a passing car and attempted to do the same thereafter. When the district court found relevant defendant's lack of felony convictions, but did not consider defendant's misdemeanors, which included reckless conduct and especially relevant in the G5 context, obstructing identification. And the district court incorrectly concluded that based on defendant's post-indictment, pre-trial release conduct, that he was not a risk of danger if armed with a firearm. As to, excuse me. I'm sorry, Judge Rovner, did you have a question?
Oh, I have a cough.
Oh, I apologize. As to the appellee's contention that defendant was just firing warning shots and that the police had told the individuals there to arm themselves, I'd first note that those facts weren't found at the district court. But even if true, the defendant in fact conceded that he was armed before the alleged police order to arm himself. And again, even if true, his conduct was such that he poses a risk to the public and can constitutionally be disarmed under 922G5. If there are no further questions, the government requests the court reverse and remand to the district court.
Thank you, Ms. Steindorf. Thank you, Mr. Briskman. The case will be taken under advisement. All right, we'll now move to Appeal 24-1942, John Clug versus Brownsburg Community School Corporation. We'll begin with argument from the appellant, Mr. Cortman.
Good morning, Your Honors. My name is David Cortman. I represent the plaintiff appellant, Mr. Clug. May it please the court. Mr. Clug served as an outstanding orchestra teacher for several years until Brownsburg forced him to violate his religious beliefs by speaking a message that he objected to. This is a critical fact, as Mr. Clug simply asked not to be forced to speak but rather to remain silent on this controversial issue. But Brownsburg's first response to Mr. Klug raising his religious objection was to suspend him pending termination. That was the beginning of the Title VII violation.
That was not, forgive me, but that was not, as I recall, the first response. The first response was to give him the two accommodations that he requested.
Actually, Your Honor, the very first response on the first day of school, when he voiced his objection, was to suspend him pending termination. When Mr. Klug returned on that following Monday to sign the paperwork that gave him the option of complying with the policy or resigning or being terminated, that's when Mr. Klug came up with the accommodation of using the last names. So the very
Right,
first...
after he had discussed it with his pastor, yes.
Yes.
But the first, all right, I won't argue with you, but
And the reason I bring that up, Your Honor, is Mr. Klug had no obligation to raise an accommodation in the first place. That was the obligation under Title VII and under Graf of the school district itself. So if he hadn't mentioned that accommodation of using last names, he would have been terminated on the second day of school on that Monday. The form that they gave him said either sign this, comply, or you're terminated. So it's interesting to say that because he suggested a last name accommodation, which, by the way, was just one of the other names in the Power School database, it was their actual last name, for him to be able to be terminated because he suggested using that last name doesn't alleviate the school district of their burden to come up with an alternative accommodation. And I want to talk about Graf because it specifically talks about that. Graf says that the school can't just consider a particular accommodation, such as a last name accommodation in this case, and determine it to be an undue hardship without considering alternative accommodations. In fact, Graf said it was necessary. In this case, the school has not proven that it raised any alternative accommodation at all.
Did your client offer any? I know you're saying that it's the school's burden to do so, but did your client offer any alternative?
Other than the last name accommodation, my client did not. But interesting, it is not his burden to do so. What should have happened in this case at the very beginning was the school district should have said, look, we have an issue here, we've passed this policy, we know you have a religious objection, let's discuss some sort of accommodation that'll work for both parties. If you look at the record, in fact, all 5 meetings between Mr. Klug and the school district, it was the same conversation, either comply, resign, or be fired. There was no discussion by the school district at all.
Let me ask a question, Mr. Cortman. We've got a new standard, Graf's come down. It's articulated it with regard to the entity's mission. How should we go about evaluating whether an entity's definition of its business is legitimate?
I think the way to look at it under Graf is you've got to look at the new standard for the undue hardship. Last time we were here, it was de minimis. The court called it trifling. Now we're looking at substantial, excessive, unjustifiable in the context of the entire operation of the school. So there's 2 points to that question, Your Honor. The first thing is, I think the school can define a legitimate mission, but it can't define it in such a particular way to violate Mr. Klug's rights. So for example, it can say, well, we have a particular mission here, and the reason it gave for this policy was to affirm students' gender identity. It can certainly do so if it wishes to, but it can't define that mission to then say, and Mr. Klug, by the way, you have to affirm their gender identity and violate your religious beliefs.
Well, we're talking about level of generality, right? So you've got the Indiana Constitution and laws, which are very general. Then you've got a mission statement from the school that could be read to be particular to this one teacher. We're looking for somewhere in between. How do we evaluate where that standard should be set?
I think the line is set whenever and I think this case is easy on that line, because if it sets it to violating someone's rights in your mission, I think that clearly crosses the line.
What
And
about
so
the mission of educating all students by being a welcome and inclusive place?
Sure, and I think that's permissible until you define it as the way you welcome students is by affirming their gender identity. So certainly Mr. Klug was welcoming. Everybody loved him. He's a great teacher. Orchestra performed well. The only issue here was whether the school had a right to obligate Mr. Klug to violate his religious beliefs by using this preferred name or preferred pronoun. What should have happened is the school should have gotten the parties together and said, okay, what kind of agreement, what kind of compromise can we come to? Let's have a conversation.
In the school context and looking at this new standard under Groff, can the emotional harm to students be a substantial burden on the school?
There's a possibility it could, not in this particular case, because I don't want to cover every case or possibility that could be out there, but if you look at these particular facts, Your Honor raises a good point, because the only evidence in the record is that the students were offended because Mr. Clug would not use their insisted preferred name or preferred pronoun. And so that's all the offense was. That's all we have in the record. That certainly is not enough to rise to the excessive, unjustifiable burden.
So what would distinguish mere offense from a substantial burden being emotional harm on students? Because I think you would agree, schools, especially high schools, grade schools, they're part of the mission is to make sure that students feel welcome and they're inclusive. So how there's a little bit of a tug there.
Yeah, and I think there may be theoretically. I don't think there is here. And I think we have to look at what can we allow students to insist on. These are weighty issues, so are politics, so are religious issues. And we can't just say, look to the students, we're going to allow you to insist on whatever you want and we'll make sure you get that. If the policy was defined the right way at the beginning, and I want to talk about the policy because I think this may help to answer your question. The school basically said we want to make sure that everyone is affirming gender identity. In the transgender question policy, the school has 3 carve-outs itself. And this matters to both Your Honor's question and the undue hardship. The school says there's instances where we're not going to affirm your gender identity. So for example, overnight trips are done by biological sex, not gender identity. Use of locker rooms and showers are done by biological sex and not gender identity. And so is a sub-database that the school has. So if the school says, look, there are instances where we can't affirm your gender identity, and they carve out exceptions, which then undermines the undue hardship, then they should have carved out one for Mr. Clug. And so the way they set up that policy was the issue in the first place. And back to Your Honor's question, the offense can't be students insist on whatever they want and the school has to capitulate. An example is, I was trying to think through what would be something similar to talk about. What if there is an atheist teacher in comparative religion class and the student says, and they say, well, you have to affirm God because you're in comparative religion and it'll offend the student, and the students have this sincerely held religious belief. School couldn't do that. Flip the hypo. What if there's a religious teacher and he's teaching in a class of science, and the school says, well, the science proves there's no God, and the students will be upset if you're a Christian or Muslim or whatever religion you are, and you say there is a God. Can they force him to say there is no God? There's a limit to where you can say, well, we want to make sure the students are happy, and so we'll force you, we'll compel your speech to violate your faith.
Mr. Cortman,
yes,
I want to go back to this. Does it really matter to the Groff substantial cost inquiry that only a few transgender students may have been directly impacted because others were obviously impacted by the accommodation? Doesn't the school district have a duty to each and every student to provide a supportive learning environment, even if only 2 students say they were injured by the accommodation? Why would the district be free to ignore that as a cost? You know, if we were talking about the school district's obligation to a student with a disability or a student who is in a religious or racial minority, we wouldn't be saying, well, you know, it's just 1 or 2 students. I am having a tremendous problem with that.
Yes. And Your Honor, I don't think we ignore the 2 students, but I do think Groff says you have to look at the overall context of the entire business. So I don't think we solely, I don't think we ignore them, but nor do we solely focus on them. There's a balance of how does this accommodation affect the entire operation of the school? It doesn't disrupt the entire operation.
Because look, exactly, in contrast to other cases, the employer in this case actually tried the accommodations. There were two that the employee proposed. I'm talking about the uniforms as well. And gave it a chance to work, and it did not work in the sense that it caused emotional harm to transgender students, as Mr. Klug himself has recognized. And it resulted in complaints and expressions of concern from students, teachers, counselors, parents. Why does that not all amount to a concrete showing of significant costs resulting from the accommodations? This isn't theoretical harm, it's actual harm.
There's two responses to that, Your Honor. The first one is Groff specifically says that Brownsburg cannot consider an undue hardship for a particular accommodation without looking for other accommodations. So I will grant the court's question, but it still requires more, even if the complaints amounted to an undue hardship. For the first part of Your Honor question, I think we have to look at all the students, and all my answer is, what we don't do is say the students get to decide whether a teacher can violate their rights. There's a compromise there. So go to the students and say, you're not happy with the last name? Can we come up with another accommodation? Is there something else we can do? The conversation has to be had, even if it affects the students.
Mr. Cortman, I hear you saying numerosity, how widespread is the problem that the hardship may or may not result in. Then I hear depth. What type of, how strong are the feelings that happen as a result of this?
Right.
If you've got a wholesale change that exists that's going to affect the school, that's going to be different than one class. If you've got a very strong violation of a circumstance versus something that's more tangential. Are those the types of metrics we're to look at?
Absolutely, and that's what Groff requires, because it looks at both what is the harm, and Groff specifically talked about complaints that are off the table. And I don't want to minimize the effect here and the offense of the students, but Groff says if you're objecting to the religious exercise or the religious speech, or the notion of the accommodation itself, it's off the table. That's exactly what the objection was. Because Mr. Klug was saying, look, I can't speak this message. I just want to stay silent. And the school said, no, you have to speak. He said, let's find a way where I don't have to address this controversial issue. That's the way it should have been handled for both the students and for Mr. Klug. If I may, I see my time's running down. I'd like to save the remaining
I'd
of my time
ask
for
you one more question, please. May I,
Yes.
Judge Brennan?
Sure.
You know, it seems to me, as it did, to Judge Magnus Stinson, that the school district has a right to own, to define, and its own mission. And Mr. Klug may disagree with the way in which the school district has articulated that mission, and other school districts, other employers might really choose to accept the mission of the Browns, to define their own missions, let's put it that way. But why are we not required to accept the mission as the Brownsburg School District has defined it, as we assess whether the accommodation to Mr. Klug resulted in undue hardship?
Because the mission can't be defined in the way that violates Mr. Klug's rights. He has protections under Title VII, where we're required to make sure that religious people don't have to sacrifice their job and to violate their faith. And I think that's the short answer. The mission can't be.
And okay, then help me with this one, because this has really bothered me. I want to ask you a question about religious sincerity. Can we not accept, as I certainly do, I really do, the sincerity of Mr. Klug's religious beliefs with respect to transgender individuals, and yet still consider Mr. Klug's voluntary use of the first names that the children had requested be used at an award ceremony? Why isn't it relevant as to whether there was a genuine need for the last names only in the classroom if he could use the transgender corrected names in a very, very public award ceremony with all the teachers and the parents and the community. Why not in the classroom? I mean, and isn't that, well, all right, I'll leave it at that.
No, Your Honor, because what the court has said is that you have to look at whether the sincerity is a sham. It clearly isn't a sham. Also, the court says we can't question where Mr. Klug draws the line. He specifically said what violated his religious beliefs was promoting gender dysphoria on a daily basis using the preferred name and the pronoun every single day. Because he was
So
acting like...
it's okay on the days when there are award ceremonies, when the entire community is there? That's okay.
It is according to his religious beliefs, which is what matters. He explained that by saying that he...
What religion allows you to parse out one an exception for huge crowds, but not in the classroom where the children are surrounded by their peers?
Your Honor, this court in IDI and the Supreme Court in Thomas says we don't question where the believer draws the line. It doesn't have to be consistent with his faith or his church, but it is. He explained that because he was acting like a coach in a formal ceremony, even a coach wouldn't use a last name. So he basically said under that individual circumstance, because of the sincerity of the program, that he would use that names in one instance, which is a completely different story from every single day using a preferred name and a preferred pronoun.
Why wouldn't that be a credibility issue at a minimum? I understand we can't question where he draws the line, but why wouldn't that create an issue of fact based on his credibility?
Because the reason that it's, I don't think we can go there. The facts clearly show that for someone to give up a job they love, their livelihood, after all the pressure and everything that was put on him, this wasn't just a belief that kind of came and went. He basically said from the very beginning for the entire year, even though...
And he can certainly argue that. But there are these other factors. How can we rule as a matter of law either way, that there was sincerity or there wasn't, given these other factors that question the credibility of it?
If you line up all of the facts, you have dozens of facts on one side that he has sincerely held religious belief. He gave up his career. He explained what the difference was. The court says we don't question his beliefs. Inconsistency doesn't matter. Backsliding doesn't matter. All those things matter. And all we have on the other side of the scale is one ceremony that Mr. Klug explained that the reason he did it was because he didn't think it was violating his beliefs. And since we can't decide where that line is, only he can, that one fact is not enough to override.
We also have
the
some
other facts.
evidence that some students said during the class he would slip and call by the first name. So I think we have a little bit more.
Well, I don't
evidence.
think that counts for two reasons. Number one, the policy says slip-ups are okay. It's going to happen. And when you're calling someone by a name and a pronoun for years, you do slip up. It's just a natural part of it. So that fact doesn't go to his religious beliefs. That fact just goes to common communication of something you're used to, and then all of a sudden trying to stop and change that.
Absolutely, of course, yeah.
I want to switch and ask, I know your time is over, but I want to ask one more question. I want to switch to the retaliation claim.
Mm-hmm.
So we asked for briefing when the petition for rehearing and en banc was filed. Groff came down after our initial decision, and we asked for both parties to submit supplemental briefing on the impact of Groff on this case. And you said as to the retaliation claim that Groff does not speak to Mr. Klug's retaliation claim. Given that statement in your supplemental brief, why haven't you waived your right to proceed with the retaliation claim?
I'm not familiar with the exact sentence, but
I just read it. Yeah,
Okay. Well,
I was quoting.
The reason is that what Groff ruled upon completely undercut the retaliation decision by the district court. And let me explain.
That's not what you said in your supplemental briefing. That's my point. You said something. You said Groff didn't impact the retaliation claim.
Again, Your Honor, I will look at it, but the reason, and if we did, we did. But I just want to say that the complaints that was used as the justification for the retaliation claim as a legitimate non-discriminatory reason was then taken off the table by Groff. And so once that's done, then the school no longer carried its burden of proof.
Right, I understand the substantive argument. Mine was more a waiver question up front.
I will
Thank
look
you.
at it. I do not know.
We'll be granting you a little bit of rebuttal time.
Thank you, Your Honor.
So thank you. Thank you, Mr. Cortman. Mr. Borg will move to you for argument on behalf of the appellee.
Thank you, Your Honor. Good morning, and may it please the court. Brent Borg for the Appellee, Brownsburg Community School Corporation. Your Honor, I want to start with the first basis that the district court found that supported undue hardship, and that has to do with the substantial student harm presented in this case, as well as the interference with Brownsburg's mission. There was some good discussion about how does this court go about that analysis, and Judge Brennan, you said something that I think is pretty helpful, is that in analyzing the mission, there is a level of generalities, and when you do start with the constitutional requirement that Brownsburg as a public school corporation has to be open to all students within its district, but then you get down from that 50,000-foot view, if you will, to a lower level, and at an administrative or maybe a school corporation level, Brownsburg says, well, how do we make education for our students open to all?
And I appreciate you framing that. Let me follow up on that. If the mission is affording dignity and empathy towards transgender students, was that ever documented anywhere before this litigation?
I believe that's what it is, and that's first and foremost in the outreach efforts that the administration undertook prior to the 2017-2018 school year at the high school. Bear in mind that this was new to everybody at the high school. There were transgender students at the middle school, but they were graduating, if you will, and they were going to become freshmen. So it was on the mind of administrators, and like educators, they took the position of, we need to start educating our teachers on this.
But if the mission is going to be defined that narrowly and specifically, and those words that become the mission or the policy come out during this litigation, it's hard. It seems like it's post hoc, that individuals have to rush to catch up with what the mission is if the mission is particular just to them.
Well, and I think I'm going to get to that, but I have a disagreement with Council's characterization of what the mission is, and maybe what you're getting at is when we get down to more levels of specificity, maybe the lower level or the mid-level, if you will, is a safe and inclusive environment that everybody's mentioned, but it is affirmation. That's probably not even the best word, affirmation towards transgender students. It is more in the sense that it is on par with all other students. In other words, call me by my first name, a very basic, a very common thing that I think a lot of people just simply take for granted and goes to your identity.
Why first name and not last name? Why wouldn't calling everyone by the last name be the same?
I think it is at the start, and that's how the school started with its accommodation, and they said, let's give it a try. I think that is in the spirit of what Groff requires and what reasonable accommodation requires. Is we don't quite know the answer here. Having transgender students is new to us, and it's new to everybody, and what you've requested seems reasonable. And the record bears out that the school allowed that accommodation to continue, and it allowed the accommodation to continue despite the fact that complaints were starting to percolate up within the high school community.
So I appreciate, again, you bringing that to the point, because if Groff is telling us that the entity, the school, has to show that the accommodation unduly affected the education of students by disrupting the learning environment, there's a number of ways to look at that. How many students, who is being disrupted, how are they being disrupted, all of the foundational questions that one would normally ask in a trial circumstance or discovery of circumstance. Here, we've got this set of facts. We've got a couple students, we have the counselor, we've got a parent, but we don't really know how broad this effect was during that year or how deep the effect was. It's almost as if people are automatically saying if someone is hurt or if someone's feelings are hurt, that therefore that's enough to undermine the accommodation. Your response?
With respect, I don't think that's what the evidence shows, and I don't think that's what Brownsburg was looking at. I do understand your point that you can extrapolate in almost any situation, and Brownsburg is a relatively large school corporation. But within the performing arts department, you're not talking about a tremendous amount of students. I think the record shows that Mr. Clug had maybe 40 students in a particular class, and you have 3 or 4 transgender students, and you also have non-transgender students who are indicating that there's a disruption here. So I don't.
Did they ever use the word disruption though? I think even the one parent, Daghe, D-A-G-H-E, didn't even use the word disrupt. There was talk about, some students didn't know why the last names were being used, some did. The record itself is not, and I understand there's going to be advocacy on both sides, but the record itself is not as clear, I think, as maybe is being presented.
So disruption can take a lot of forms, right, Your Honor? But I think disruption's here in the sense of some of the affidavit testimony from the transgender students of I dreaded going to class each day. I eventually decided to withdraw. I made up my mind that I was going to withdraw from the class. So it is disruption in that sense. Is it maybe disruption in the sense that, the school, the entire class could not focus, could not attend to the lesson of the day? I grant that it's not that sort of disruption.
How does the evidence in the record that the students were performing better, doing better on exams, how does that weigh into this balance of substantial burden?
It doesn't, Your Honor, and it goes back to the mission analysis. And Mr. Clug, from the outset, used a sports analogy, and I think a sports analogy is good in this instance. I think it would be reasonable for a sports program to define successes by the MVPs and by the All-Stars that it has, but Brownsburg did not do it that way.
But if your mission is to educate all students, and there's evidence showing that in orchestra and in music that they were doing better in terms of their education, why wouldn't that be a piece of the substantial burden analysis?
Because Brownsburg decides based on its mission that it has to look at it holistically. It judges success by the success of a team as a whole.
So,
And
and assume that's true, why isn't that one piece of the holistic puzzle?
I think it is, and I think Brownsburg administrators would say yes. We take that as a given. It is great that we have students over here excelling and that they enjoy the experience, but we can't forget the folks over here.
And we know that just mere offense to a different viewpoint isn't sufficient for a substantial burden. How do you balance, or where's the line between emotional harm to students rising to a substantial burden versus merely students taking an offense at a different viewpoint?
Sure. I think part of the analysis, and again, what Principal DeGay and what the administration did bore this out. He did not rush to judgment. He said this situation might even resolve itself, and that was when he was receiving information from Craig Lee, who's sitting in on these Equality Alliance meetings on a weekly basis, and saying, let's just see where it bears out, and then it starts to percolate up, and I think as the district court found, it's very important to note in this case that the evidence of the student harm and the emotional harm, as opposed to mere offense, is undisputed. So I think that investigation
I'm
process—
not sure that that plaintiff's counsel would agree with that. I'm not sure Mr. Cortman would agree that the evidence of emotional harm to the students is undisputed. We can ask him, but I'm not sure he'd agree with that.
Well, and I want to get to the root of your question, Honor. I think Principal DeGay's efforts to bear this out is that he started conducting inquiries, and I think that's sort of a sorting process to determine, are we dealing with students who are merely offended by the conduct, or are we dealing with students who are saying, this is dehumanizing me, I'm dreading going to class. And he's not only he's hearing that from an Equality Alliance teacher who's the sponsor for the club. He's hearing that from the co-chairs of the Performing Arts
Would it
Department.
be an undue burden if one student said that and nobody else?
Yes, if there's emotional harm
To one student?
Yes.
That would be an undue burden.
yes, that could rise to that level. Obviously, there's a continuum there, and Gross says you need to consider the size and the nature and everything else, but certainly that could be the case when you consider mission. Another thing that I think hasn't been brought up today, but I think it's important to mention, is this is not the student's personal preference. This is the student backed by a healthcare professional and backed by the parents, saying it is in the best interest of my child. As the district court, I think, noted, the school, again, when you go back prior to the 2017-2018 school year, it was sort of a search process. This was new to the high school, and as the district court noted, they reasonably deferred to the judgment of the healthcare provider and to parents. They weren't just going to allow a student to come in and say, hey, call me this name and accept that at face value.
Mr. Borg, you began with the two reasons that the district court relied upon: the mission and whether or not the undue hardship, there was a problem with that, and secondly, the Title IX liability. The cases, though, that are cited that would potentially put the school district at risk for Title IX liability, those are ones in which the transgender student was treated differently than other students. Isn't it the case here that the students were all being treated the same by Mr. Clug?
For purposes of our summary judgment, yes, they were. I think we need to make that assumption. But I think the Whitaker case is in alignment with it, Your Honor. Whitaker was decided just several months before, I believe, the start of the 2017-2018 school year. You have instances in the record where there is mentioning of a recent court case that has changed the law in this area. And as I understand Whitaker, I think it is recognizing that the argument of a gender-neutral bathroom was rejected because the court, and I'm paraphrasing here a little bit, said that is the policy itself, and a gender-neutral argument is not going to get past the court's grant of a preliminary injunction. Here as well, if if Brownsburg rather allows the last name only accommodation to continue, it is in light of all the harms that have been demonstrated by this record, in light of all the concerns that are raised by the teachers and by the other stakeholders in the high school community, it is condoning Mr. Klug's neutrality when the underlying reason that he's doing that is on the basis of a student's transgender status.
What's clear?
And isn't it, or is it so? Well, no, isn't it so that Mr. Klug admitted that he caused emotional harm and was pleased because his practice was effective as to the students?
I think you can read it that way, and maybe to take a step back from that, Your Honor, Mr. Klug conceded in his deposition that a school corporation has an interest in the emotional well-being of its students. And certainly from Principal DeGay's perspective, I'm sorry.
No, go ahead.
Certainly from Principal DeGay's perspective, that's the conversation you're referencing, that's the second part of that. Again, he's taking a slow approach to this. He's taking a patient approach, and when the complaints start to percolate up or reach a critical mass, he doesn't make a rash decision. He doesn't just say no more accommodation. He goes to the object of those complaints, namely Mr. Klug, and he says, you know, John, we have a problem here, and he's putting this information at his feet. And Judge Rovner, to your point, his response is, there's no problem at all. I'm going to continue what I'm doing, and that's, you know, not in the nature of the type of discussion that reasonable accommodation requires. I know there was earlier conversation with counsel of Groff's requirement that the employer can't just provide one accommodation and then throw in the towel, so to speak. We accept that, but the evidence is undisputed in this instance that no other accommodation was available with regard to last names. Mr. Klug was the only orchestra teacher at the high school. He was the only person who taught the music theory classes, so there was nothing else that was proposed or nothing else that could be done, and that's been undisputed throughout.
Well, for example, they did on the uniforms. They had someone else give out the uniforms, right? The band uniforms.
Yes,
yeah.
That's correct. And that accommodation never changed.
To follow up on the mission, the Title IX question, the very fact that this case has been so litigated in such a manner shows that the potential liability was not clear to the school district, right? I mean, we've got huge disputes over the facts. We've got disputes over the law. It's the legal standard itself has been changed by the Supreme Court during the course of the litigation. This is not clear nose on face that the school district would be walking into a problem if it did what it did, right?
I don't think that's, with respect, Your Honor, I don't know that that's correct. I think it should be enough for this court to say Title IX prohibits discrimination on the basis of sex. That's certainly been extended in a Title VII context to transgender status. And I don't think, you know.
It certainly does protect transgender students against discrimination, but back to Judge Brennan's earlier point, the policy here was applied to everybody. So everybody was treated the same. How would that expose the school to discrimination against transgender students when they're treated identical to other students?
I believe that's the same argument that this court rejected in Whitaker, namely a gender-neutral bathroom does not satisfy, because the reason the school is providing the gender-neutral is that is discrimination based on the transgender student's status. Here as well, the reason that Brownsburg is extending the accommodation is because Mr. Clug refuses to call transgender students by their first names.
You can continue, because I'm going to give him some rebuttal time if there's the last couple minutes you'd like to cover.
Just very briefly to address the retaliation claim, our position is that it's a very simple and straightforward analysis. This court defined the scope of its remand order, and it required the district court to address Groff under its clarified standard. As the district court noted and gave very short thrift to the retaliation claim, Groff does not concern a Title VII retaliation claim at all. It concerns the undue hardship standard for reasonable religious accommodation under Title VII. This court, I suppose, could have the authority to interpret its order, and it could have the authority to revisit its order, but could is different than should. And
What about the
it should
fact that we vacated our entire opinion, including the retaliation aspect of the opinion?
The evidence has not changed, Your Honor, and I think the
Well,
question,
that's, if there is an issue of fact on whether or not it was a legitimate reason, the law has changed.
the law has
So
ta-
putting aside the merits and whether or not you should prevail on the retaliation claim, just in terms of the scope of the remand, while we did say in the remand, we send it back to address the religious accommodation claim, we vacated our entire opinion. So what would be the procedural problem of addressing the retaliation claim in light of the fact that we vacated the entire opinion?
The court could certainly do that. If it were to do so, it should consider the prejudice to Brownsburg, that it did not. It's effectively two bites at the apple for Mr. Klug, based on the happenstance of the Supreme Court handing down Groff and changing a standard that has nothing to do with Title VII retaliation.
Mr. Borg, without getting into any attorney-client privilege communications, at one juncture when the case went back to Judge Magnus Stinson, and the parties were engaging in discussions about the way the case would be handled on remand, there was an order that indicated that no further discovery was going to be taken. Was that based upon a discussion, again, without getting into any privileged communications, discussion among counsel, discussion with the court? Was it just kind of an assumption?
Forgive my memory might be faulty, but I believe there was preliminary discussion among the parties' counsel, and neither side felt very strongly about reopening the record. And based on that lack of interest, it was mutually decided that we went to the court and said, everyone's in agreement that we don't need to reopen the record.
Thank you, I appreciate that.
Brownsburg respectfully requests that this court affirm the district court in all respects. Thank you for your time today.
Thank you, Mr. Borg. Mr. Cortman, we'll give you 3 minutes for rebuttal. If I could prevail upon you to answer that final question that I posed to Mr. Borg about reopening discovery.
Yes, Your Honor. My recollection is the parties discussed it and decided that there was no need to reopen discovery. And I think the reason for that, at least in our opinion, I won't speak for the other side, is discovery was fully done and completed. There were document exchanges, there were depositions taken. There was no more facts that needed to be put into the record. And that's why our point here, in fact, this court and the court below, ruled everything as a matter of law. And the reason is there's no outstanding facts that need to be discovered. The question is, when you have all these facts, which both sides agree to, the only question is, what's the legal interpretation of those facts? So we believe that more facts won't change anything, even though the court changed the standard. I want to point out just a couple of things in my time, if I may. The retaliation claim, real quickly, I read what Your Honor said. Groff does not speak to the retaliation claim. In and of itself, it's absolutely true. I would say, though, that it did affect the retaliation claim. We were talking in that section about the legal standard, so Your Honor is absolutely right. But it doesn't mean there was no impact that Groff had on the retaliation standard. And I think the complaint being taken off the table takes away the legitimate non-discriminatory reason. And so I think, and we've been briefing it both before and after for the last 7 years, so there's obviously no prejudice when both sides have briefed that issue for the dozens of briefs here. I also wanted to talk to one point about the complaints. I know there are some differing opinions about it. What I want to emphasize is that regardless of the complaints, the school district had an obligation to consider alternative accommodations, and it never did. So even regardless of how the court feels about the complaints, what kind of offense, what kind of impact, what I would say is regardless of those, Groff says it's necessary, even if you find hardship on a particular accommodation, to explore other accommodations. The school has not carried its burden. In fact, the evidence shows there were no other accommodations for his speaking. Yes, there was an accommodation for the uniform, but one accommodation on one thing doesn't eliminate the need to accommodate his being forced to speak a message that he disagrees with. So that is still there, where they didn't carry their burden to show. They explored alternative accommodations, even putting the complaints aside. The last thing I want to say, and I appreciate the extra time, Your Honors, is that Groff substantially changed what we're looking at here. There's a sea change from trifling or de minimis to excessive, unjustifiable in the overall context of the business. And I think if you apply Groff's standard here, then summary judgment should be granted to Mr. Klug on both of his claims. If there are no further questions.
Judge Rovner, any further questions?
No, but thank you. Thank you, Mr. Cortman.
Judge St. Eve? Thank you, Mr. Cortman. Thank you, Mr. Borg. The case will be taken under advisement. The court's going to take about a 10-minute recess at this juncture. All right, we will continue with the third case of the day. This is Appeal 24-2021, Jacqueline Sterling versus South Lake Nautilus Health and Racquet Club Incorporated. And we'll begin, Mr. Sheelist, with an argument from you on behalf of the appellant.
May it please the court, I'm Sam Shellis for Jackie Sterling. We believe the court below erred in a series of ways de novo. First, as to the affirmative defense, which was the primary defense in this case, contributory negligence is made to the defendant's burden, which the court did not indicate. And secondly, it's not made by chance. The court said there was a chance that the following of the rule, the local rule 4004, would have made a difference. It is not more probably true than not, which in our view is an error of law, but most urgently, the defendant has argued that the violation of the rule is contributory negligence. Contributory negligence is not the violation of the rule. Contributory negligence is the violation of the rule proximately caused what happened. So those three errors of law led to an error, in our view, as to the facts. There are no facts in this record that indicate the failure to give notice under Rule 1004 to the local circuit court would have caused that writ to be recalled. The proximate cause of Jackie Sterling spending 3.5 days in a jail cell, handcuffed, with no female napkins. The proximate cause of her being jailed was the defendant issuing a writ in direct contempt of the bankruptcy code.
What evidence of damages from the arrest do you claim weren't accounted for?
The damages that were not accounted for are, number one, loss of reputation and loss of liberty. Let me talk about loss of reputation. The court below erred in examining loss of reputation as an independent cause of action.
But the court discussed it and looked at reputation, and she got her job back, she got her licenses. It factored all of those facts here in.
I respectfully disagree that they did, and here's why.
You just don't like the amount. I mean, it sounds to me like you're asking us to reweigh the evidence, to say she lost her reputation for this certain period of time, and the court didn't give enough weight to that. But that's reweighing the evidence, which is what we can't do.
The reason I think it's an error of law is loss of reputation for the implication of a criminal act is per se damages. It is when a person such as Jackie Sterling has been arrested, the horseshoe records, and they're not lawyers, the horseshoe records indicate this implies she committed a criminal act. The implication of a criminal act entitles her to per se damages. So when the court examined loss of reputation, they said, there's no harm, no foul, she got her job back. That is incorrect. She now has a record that she has to explain. And 10 years later, after the unfortunate events, to get her gaming license, she had to explain away the arrest record. So in other words, it does not account, and we cited a case where the judge, as a matter of law, errs by not accounting for the consequences of this contempt. This is, after all, direct contempt of a court order. The natural consequences should be paid for and punished. And the one that we focused on, which was your question, is loss of reputation. Your reputation is not restored because you got your job back. Your reputation is not restored because we were able to explain the arrest to get her a gaming license. Your reputation is damaged as a matter of law. We cited some law review articles that are important to note that an African-American citizen with an arrest record has a terrible situation facing her. For the rest of her life, she has to explain an arrest that never should have occurred. There is no basis for this arrest. And I would also note that the loss of her liberty, spending 3.5 days in these terrible circumstances, is a natural consequence. And to follow up your question, the court analyzed loss of reputation in terms of an independent tort. I am not permitted to bring a tort case. I wish I could seek a jury. Instead, we seek to punish the defendant for his contempt. And one of the ways we do that is to make sure they pay the consequences of the contempt.
Did you present any evidence that the fact that she was arrested has prevented her from getting a job, has caused any other challenges for her?
We presented evidence that we had to explain the arrest to get a job in Colorado, and she did get the job.
She got the job, and the court
But that
considered
distinguishment, Judge, doesn't take into account the damages for the implication of a criminal act are per se, and we shouldn't have to identify actual damages. That's what loss of reputation is. When you imply somebody
But you
committed
have to prove actual damages. And if
actual damages for a per se violation are per se. In other words, you don't have to prove.
what are you relying on for the per se violation? This isn't a malicious prosecution claim, so that law doesn't help you. In the bankruptcy context where you're arrested based on an arrest warrant that was issued because you didn't appear, what law are you relying on that there's a per se violation?
Well, we cite cases, Judge, that indicate that
You cite cases from malicious prosecution and other
context.
causes of action.
But because we cannot seek tort causes of action, the only way to analyze or
So you're trying to take these tort concepts and impose them in the bankruptcy concept. And
Yes.
my question is, what supports that here for your argument of per se damages? Because I haven't found any cases saying there are per se damages in this context.
because
for an
this
arrest.
case is sui generis. There
So
are
if we
no
don't
reported-
accept your argument that there should be per se damages for this,
Excuse me?
if we do not accept your argument that there should be per se damages for her arrest, what's your strongest argument of the evidence you submitted of the harm this arrest caused?
The strongest evidence.
Based on evidence in the record only.
I understand. The strongest evidence is, number one, there is a permanent record at Horseshoe where, of course, she had her gaming license with the implication of criminal act, which is untrue. Secondly, in order to get the gaming license, we had to disclose the arrest and explain it, and we're going to continue to have to do that for the rest of her life. In other words, most jobs you're going to get asked, is there an arrest?
Is there any evidence she's going to leave her job that she has now, that she got with the arrest?
I have no idea what she's going to do in the future, of course not. But I can tell you that the harm is having to explain a permanent record that we cannot expunge. In a criminal situation, of course, we could expunge the arrest record. We can't do that here. It's a permanent record.
And you have already had to in Colorado.
That is correct. And I would emphasize, respectfully to your question, it is a damage to have to explain to new people, I was arrested, but I wasn't guilty of anything, or I had to file a bankruptcy and this arrest came about that shouldn't have come about, to answer the question. That, to me, is an act of damage that the court didn't consider. When it wrote its opinion, Judge Ehler said, I'm not going to consider that because she got her job back. But that, in my view, is not what reputation is about. Let me also emphasize, in answer to your question, we have no choice but to analyze this case in terms of tort principles. And here's why. When you look at the defendant's brief and all the briefing below, counsel says, quote, the proximate cause of plaintiff's injury is the failure to follow the rule. Proximate cause is a tort concept. The only way we can analyze this case, which is sui generis, there are no other reported or very few reported cases similar to this, is in terms of tort. Because that's what the proximate cause defense is. And let me emphasize that the reduction of 50% for proximate cause is not based on what happened, based on the clerk of the circuit court indicating that this notice would not have recalled the writ. And we know on the Monday she was in jail. They couldn't get her out of jail on a notice. They had to bring an emergency motion and have the file pulled. That wasn't their procedure then. I realize that we're younger people now, and this is an email world, but at the time that didn't happen in the circuit court. I realize I only have a few minutes to reserve for rebuttal. Let me discuss my fees, obviously an issue of some importance to me. The court below determined my reasonable fees after 12 long years of litigation were $199,000. That should have ended the inquiry. Reducing my fees for the client's contributory negligence, although we don't believe there was any, is inappropriate. There's nothing in the order that the court cites for authority to reduce my fees by 50% to apply the contributory negligence of a client to me.
Who, Mr. Sheelist, had the duty to give notice under the local bankruptcy rule? Was it the client, the attorney, both?
The attorney had the client ultimately, because I guess you could file a pro se bankruptcy, was obligated to send a notice to the circuit court of any case that was pending. But I want to emphasize, as strongly as I can, the record is resolutely clear that the circuit court clerk testified if we got this errant notice, it would go in the garbage can. The file would not be pulled, the writ would not be quashed, and nothing would happen. Now that may be criticism of the local court system's procedures back then, but proximate cause is not made by chance. And the court below said, there's a chance, and counsel says there's a chance things would have been different. That doesn't meet the standard, and the court should reverse on proximate cause. There is no evidence to support it, and certainly restore my fees. The last point I would make is you remanded plus costs to award no costs in this situation would mean my client essentially receives nothing, and that is not a fair result. I ask, since my time is running short, for rebuttal.
Thank you.
Real quick, if I could ask one question, please. On the cost issue, is there any rule in the bankruptcy court for the Northern District of Indiana that sets a time limit for filing a bill of costs?
Not that I know so.
Okay.
I don't believe so. Thank you. I
Thank
ask
you.
for a few minutes in rebuttal.
Yes, that'll be granted. Thank you. We'll now move Mr. Steele to you for argument on behalf of the appellee.
Thank you, Your Honor. Kevin Steele on behalf of the Appellee, South Lake Nautilus Health and Racket Club, Inc. I think the briefs make it clear here what the issues are, and I disagree with the standard of review provided by Mr. Schellest at the beginning of his argument. I believe that the matter is to be reviewed for an abuse of discretion, that a civil contempt award by a bankruptcy court for a willful violation of the discharge injunction is considered a sanction, and that this court reviews the bankruptcy court's imposition of sanction for abuse of discretion, not de novo. And I believe...
if you're, when you're done, go ahead.
No,
Finish your thought.
I was going to move on.
Yeah, that's good, because I want to ask you about the decision to cut the attorney's fee award in half, based on the finding that the client, Ms. Sterling, was 50% at fault. I really am struggling here. What does her degree of fault have to do with the reasonable number of attorney hours spent on this case and the appropriate fee for those hours? Wouldn't Ms. Sterling's attorneys have been required to devote the same amount of time, put on the same evidentiary case to the bankruptcy court, even had they known from day one that her damages would be reduced based on her degree of fault? I mean, even in retrospect, we can't say that simply because the bankruptcy court found Ms. Sterling 50% responsible for her injury, her attorneys should have devoted 50% less time to her claim, can we?
Your Honor, I don't envision the decision of the court in that context, because when the case was remanded the last time by this court, the final sentence of that opinion was, "We leave to the bankruptcy court's discretion whether to factor this into the damages calculation," which is talking about the failure to comply with local bankruptcy rule 4002-1A. And had that rule been complied with, Mr. Schellest spent some time talking about testimony from a retired individual in the clerk's office about what it would happen if that notice had been provided. But the other part of providing that notice is providing the notice to the attorney who filed the case. And the testimony at trial of this matter from Mr. Ostian, who was the attorney on behalf of my client, was clear that his office had received that notice of bankruptcy. They would have recalled the warrant and abated all collection activity at that point in time. So the failure by Ms. Schellest and her attorney contributed to this situation, and the court found that that fault, that failure to mitigate damages is the other way to look at that, was worth, in essence, reducing the damages award by 50%. And the problem, I suppose, Your Honor, with the Mr. Schellest imposition was he was not the attorney who filed the bankruptcy. But that attorney failed to comply with the local rule, which created the circumstance. And so in your analysis there, it creates a situation where if the plaintiff obtained a new attorney, somehow you get away with it because you changed an attorney. And I can't believe that that's the meaning of what the rule would require and the damages that flow from that.
Injuries like this one involve a deprivation of involving a deprivation of someone's liberty are inherently very difficult to quantify, and they often result in only minor awards of damages. And arbitrarily having, halving the fee award based solely on the fault of the plaintiff would, in my mind, really serve as a disincentive for attorneys to take these kinds of cases.
Though, Your Honor, I suppose I would say it also incentivizes attorneys to comply with the local rule, which I think the testimony was clear at trial and the orders entered by the bankruptcy court were clear that had the local rule been complied with, this situation never would have occurred.
Well, how should we factor in the fact that you didn't follow the local rule either, right?
No, Your Honor, there was no obligation on the local rule for Southlake. That the local rule that we're talking about required the debtor and the debtor's attorney to provide that notice in any civil action pending against the debtor at the time of the filing of the bankruptcy.
And on that topic, is it a disjunctive, a conjunctive? Whose duty really is it? Client, attorney, both?
Both.
Because it's written in the conjunctive, or because the attorney stands in the shoes of the client, or this is why she spent the time in jail, is that they didn't get it, and that's what we have to find
That's
out.
correct, Your Honor, and I think that it generally, in practice, is the attorney who files it. Obviously, as indicated by Mr. Schellest, in a situation of a pro se bankruptcy, the debtor has that obligation. Generally, the obligation is fulfilled by the debtor's counsel, who files the notice to the court, which, as indicated, would have led to Mr. Ostian withdrawing the warrant and preventing the situation from occurring. With regard to the damages award that was made, we don't believe that the court abused its discretion in determining the amount of the award for each of the nights that Ms. Sterling spent in jail. The court pointed to other cases where individuals had spent nights in jail in bankruptcy context and awarded a bit more than those cases for each one of those nights. The standard, that we look to in the abuse of discretion context is whether the bankruptcy judge acted within the reasonable range of options available to a judge sitting in that situation. And I think that the bankruptcy judge supported his imposition of damages for the nights in jail by pointing to other instances and making a similar award, in fact, a little higher than those similar cases that he pointed to.
As a result of Southlake's violation of the discharge order, Ms. Sterling has an arrest record. And look, of course I understand she didn't lose her job and she hasn't lost her gaming license. But how can that mean that she suffered no compensable harm from the arrest? Apart, from the indignity of the arrest itself, doesn't she suffer from embarrassment, the burden of explanation every time she has to disclose the arrest? She may very well wish in the future to move or get another job, and to have to explain away if she even gets that opportunity, because once an employer sees arrest, they very often just sort of move on. Well, why is that not compensable?
Well, Your Honor, I believe that on the remand after this court's decision, the only testimony that was presented at the trial was that of Mr. Schellest with regard to his attorney's fees. So the statements with regard to what Ms. Sterling may or may not have to do were argument that were made by counsel at the conclusion of the case. We have no evidence of what she will or won't have to do into the future, and nor do we have any evidence to support what damages are attributable to that.
She didn't testify at that hearing, correct?
She did not testify at that hearing. And so I think that within the realm of the evidence that was supplied to the bankruptcy court made the best decision that it could, given the evidence that it was presented with regard to the potential impact on Ms. Sterling. With regard to the cost argument,
Mr. Steele, I'm going to ask you
yes.
the same question I asked of plaintiff's counsel. Is there any rule in the bankruptcy court or in the local rules that sets a time frame for filing a bill of costs?
I am not aware of one.
Because we have said that a prevailing party can wait until after appeal to file one. And I didn't see any rules or local rules or standing orders that said you have to file within X time.
I am not aware of any such rule.
Well, she did ask for her costs in the pre-hearing briefing, but Judge Ayler never said anything about costs in his decision. And I mean, of course it's true, as Judge Simon pointed out, that she didn't itemize her costs in the briefing, but typically a bill of costs is submitted to the court after judgment. So I'm really wondering why we shouldn't remand for reconsideration as to costs.
Well, obviously, all that we're saying is that the reason why the court didn't award any costs was because the bill of costs was never filed. And so to come up on appeal and say, hey, you should award costs, well, you still haven't submitted your bill of costs to ask for costs. And I think that's what Judge Ayler and Judge Simon were both saying is, well, of course the court didn't award any costs because there was no request made for the costs other than a statement at the end of the wherefore paragraph asking for an award of costs. With regard to the reduction of the damages and the attorney's fees, I believe that I've cited to case law that indicates that a bankruptcy court has the authority to make considerations necessary to allow for a reduced award of fees based upon what has happened in the case. I believe that in this particular case, the actions, not of Mr. Schellis, but of the debtor's counsel, leads to a conclusion that the fee reduction was appropriate. There's also statutory law under the bankruptcy code that I cited to that allows for the court to make a determination of what fees it may or may not award in a particular instance. I believe that the court in this particular instance did not abuse its discretion, even if the court, now looking back at it, disagrees with what the judge perhaps did. It was within the range of a reasonable action by a judge, and he did not abuse his discretion. And Southlake would ask that the court affirm the decisions made by Judges Ayler and Simon. Thank you.
Thank you, Mr. Steele. Mr. Schellis, you're up next for rebuttal argument.
First, let me correct. Rule 4 does not, 4004 does not, both judges rejected this, require notice to Mr. Austin, the creditor's attorney. It required notice to the local circuit court. Both judges rejected that was the meaning of Rule 4004. So when counsel says if Mr. Austin had received the notice, he wouldn't have issued the writ, the rule does not say that. The issue here is when the notice goes to the Superior Court, Lake County, what they would have done with it. And we know what they would have done with it. Nothing. There is absolutely no dispute in the evidence that the Circuit Court in Lake County did nothing with bankruptcy notices, and the proximate cause of this arrest was not the violation of Rule 4. Counsel's own brief says, we have examined this in tort principles as proximate cause. What is the actual cause of the arrest? Was the writ issued in contempt of this court's discharge? As to the fees, I am the prevailing lawyer. I hate to discuss fees this way. It makes me feel uncomfortable, but I have spent 12 years on this case. I prevailed in the Court of Appeals last time. I have argued this case to trial. I have argued this case for 12 years. The contributory negligence, if it exists, has nothing to do with my fees. And it is an abuse of discretion, and there is no rational basis to reduce my fees by 50%. As to the costs, I, of course, would itemize when the case is over, but the case wasn't over, so we didn't itemize the costs. I want to talk again, though, about the
When you say the case is over, what do you mean? What time frame?
When
case
there's
is over in the bankruptcy court, district court, our court?
When this case is over in the sense of there's no appeal and there's a final judgment that's not being appealed, within the 30 days, I would file a bill for costs. But since I was appealing on behalf of Jackie Sterling, there wasn't any point in bringing a bill for costs at that point. And I would also note, as noted by Judge Rovner, When you remanded the last time, it said plus costs, and I hadn't yet itemized because there wasn't any reason to. Judge Ayler never gave a reason for not giving me costs.
He didn't address costs at all.
He didn't address
say
it at
you
all.
couldn't get them. He didn't say anything, right?
He didn't say anything, and I think that the rule, as I understand it, is costs are, the word is must. And so I ask that you must allow me to get costs. Let me just talk about Jackie Sterling in final moment. This is a person who should never have been jailed. There is one and one reason only that she spent in jail, and that is because a creditor chose to issue a writ. When they got the notice of discharge, and before that the notice of automatic stay, they could have picked up the phone, called their lawyer, and said, close your collection file, what's going on in the case, and be told there was a writ of attachment issued, withdraw it and do something. This creditor thumbed its nose, as Judge Simon said, at the bankruptcy procedures. They're the ones in contempt, and we ask that you reverse for the reasons stated. I thank the court for the opportunity to speak to you today.
Thank you, Mr. Shawless. Thank you, Mr. Steele. The case will be taken under advisement. We are now going to move to appeals numbered 23-3388 and 23-3110, Patrice Daniels et al. Versus Eddie Jones et al. We're going to begin with oral argument on behalf of the appellant. Mr. Hirschman will recognize you.
Thank you, Your Honor. Harold Hirschman on behalf of the appellant. The district court ruling that it suddenly lost jurisdiction while the parties were preparing for trial has no legal basis. None has been cited by the appellees. None was cited by the trial judge. Indeed, remarkably, the trial judge at A16 actually said any right to return the matter to the trial docket survived only as long as the consent decree did. It is undisputed fact here that it was returned to the trial docket on July 21. The consent decree, by everyone's count, ended on July 22.
When you say return to the trial docket the day before the consent decree ended, what do you mean?
Literally, the judge's order says, I hereby return this case to the trial docket. That appears at A36.
Well, your argument presumes that the consent decree date would not have effect because of the case being on the trial docket. Is that correct?
Correct.
Why wouldn't the consent decree date have effect, notwithstanding the presence or absence of the case on the trial docket?
If I understand Your Honor's question correctly, what that means literally is the consent decree is over. And so it doesn't impact the next set of proceedings. It isn't that we can go back and say, oh, you promised us X or Y or Z in the consent decree. And so that's why the issue, remember, this is a jurisdictional issue that Judge Mims says he was relying on.
Well, that's part of the problem is there's the nomenclature here is not consistent because we've got cases that use mootness. Some say case in controversy. Some say jurisdiction. What those cases do seem to have in common, though, Mr. Hirschman, is this idea that once the consent decree ends, that ends the case. And I understand how you'd be troubled with the language Judge Mim would have used, but can you address this idea that the consent decree isn't ended by its own terms?
Because if you look at A21, which is what the parties told the court in June, the parties said, we have a dispute, we have a problem. The consent decree has not solved the problem. The consent decree has not been complied with, as this court acknowledged in its rational opinion. And so where do we go from there? The case
Mr.
has not.
Herman,
I'm sorry?
I'm sorry. What was left of the case once the second settlement agreement or consent decree expired on July 22nd? The only outstanding violations, weren't they resolved by the decision in Rasho, which said that there was no ongoing Eighth Amendment violation as to the areas that were addressed in the permanent injunction?
There are two parts to my answer to that. First is there were 42 items under the consent decree which had never been resolved and which the rational court recognized were not in front of them. That's one. Two is that the rational court was applying the law to a situation which existed in the IDOC 2 years before the opinion came down. And what they said was, that 2 years before, they believed that there was sufficient diligence to address these issues. Not that they'd been solved, not that they weren't serious, but that the IDOC was working on it. That says nothing about the future. That isn't a get-out-of-jail-free card forever with respect to the failure to have enough staff or the failure to deal with people in crisis. That would turn the whole law on its head because it would suggest, and the courts have said repeatedly, if you are walking down a path which ultimately fails, we can look at that and we can decide whether it was reasonable for you to continue down that path. So with respect to the decision of the rational court, it was twofold. At the time at the time of the trial, it believed there was sufficient effort being made to solve the problem, including, for instance, the hospital. The hospital hadn't opened yet. The hospital didn't have any staff. The last time we looked at the hospital, it had opened, beautiful building, no people in it. 150 beds, maybe 30 beds full. Now, how can it be that building an empty hospital solves the problem of acute care?
Mr. Hirschman, did the settlement agreement resolve all of the claims of the parties up until the filing of the Fourth Amendment complaint?
It was supposed to if it was fulfilled. And that's why Judge Mims' order of June of his order approving the settlement said settlement wouldn't be fair if I wasn't supervising this, if I wasn't available. And the Seventh Circuit picked up that language at page 4.
Right, it said it's a consent decree, but it was supposed to resolve everything, right?
It is supposed to resolve everything
And
if
there was this deadline for the court's jurisdiction of July 22nd, 2022.
there was, and that is when the consent decree was supposed to end. And then the next question was for the court, is there anything left? Should we continue with this case or not? And the court had already said the day before, we're going to continue with the case. Why? Because he said...
Was that just because of the Fourth and Fifth Amendments, amended complaints that were filed, though? Was there anything left of the case up to the point before the Fourth and Fifth amended complaints were filed?
Yes, there were unresolved issues which the judge acknowledged were not, had not been accomplished by the defendants that they had promised. And there had not been a trial on those. There had not been, but there was an order specifically, and we cited in our brief, I can't remember it off the top of my head, that there were some 40 items that had not been complied with. So the judge knew that. And he knew further that what the Seventh Circuit had told him was not dismiss this case. That would have been in the mandate. If the Seventh Circuit believed the case was over,
I'm not sure about that, given the limited issue that was before the court. They didn't send anything back.
Well,
so I don't know that that would have been an advisory opinion from the court saying the case is over. That's not what the appeal was about.
Exactly. That wasn't what the case was about. It wasn't whether everything had been complied with. I'm sorry, Your Honors.
You can reserve your time. Thank you very much, Mr. Hirschman.
Could I just?
Sure,
Judge
Rovner.
Were there new claims after the Brasho appeal?
Were there new claims? There was a continuation of the failure of care in a different time frame. Obviously, we couldn't, at the time of the settlement, say, we're settling this for all times. It doesn't matter what you do, how miserable the care is. And so that isn't what we did. We settled the third complaint, but the judge said, and the defendants didn't even move to dismiss on jurisdictional grounds when we filed the fourth amended complaint. Why? Because
but there were new claims in the Fourth Amended complaint, correct?
There were several new kinds of claims. We had equal protection claims, which we hadn't had before. Right. We tried to add the governor as a party, but the defendants answered the Fourth Amended complaint with respect to the prison conditions. And, if you look at Rufo, Rufo is on point that it is not, the trial court has to look at the situation at the end of the consent decree and decide what is just and reasonable. And we say that's exactly what happened. And then,
I take your point that the Fourth Amendment complaint brought new claims into the case. But am I wrong if I thought that complaint was not filed until September 2022, 2 months after the consent decree expired, which would leave no live case or controversy in those 2 months?
But there's two answers to that. One is we were permitted to file an amended complaint, which is always jurisdictional. That is to say, you can't lose your jurisdiction when you've told the court, when you told the person, a person in our position, that they can file an amended complaint. You can't then just pull the rug out and say, whoops, there's no jurisdiction. There was jurisdiction when he told us we could do that. And further, the issues in the third amended complaint and the problem with what was going on at the IDOC had not been completely resolved. And there was no order dismissing the third amended complaint till 3 years later. So it's impossible to say under any way that we had noticed that the end of the consent decree was the end of the case. That isn't what the judge said then. It isn't what the meaning is of the consent decree, and I know I'm way over time.
No, but what 40 claims are you talking about? How different are those claims from those that were under review in Rasho? Are you saying 42 areas are new, not overlapping with the areas that were addressed by Rasho?
Absolutely, I'm saying that, Your Honor.
Oh.
And they were subject to the settlement agreement?
They were subject to the settlement agreement. That's how we know that they weren't complied with. There is an order. One of my helpers will give me the order when I get up next, and I'll tell it to you. But it is absolutely clear that there were areas that were not covered by the injunction.
So if I understand you correctly, you're saying you had a settlement agreement. The court retained jurisdiction because it was overseeing the enforcement of it.
Yes.
But the settlement agreement fell apart because everything wasn't complied with, and therefore it wasn't a final order.
Correct. It couldn't be.
Thank you, Mr. Hirschman. We'll now move to argument on behalf of the appellee, Ms. Hanson.
May it please the court, counsel, I'm Assistant Attorney General Christina Hansen on behalf of the defendants, appellees, cross appellants. The district court correctly concluded that this case terminated upon the expiration of the consent decree, and thus that any new claims that plaintiffs sought to assert had to be raised in a new lawsuit. But it erred when it concluded that the defendants were not entitled to a refund of the $1.9 million deferred fee award that they were ordered to pay upon issuance of the now vacated permanent injunction.
What's your position on whether or not all of the terms of the settlement agreement were met as of July 22nd, when the court's jurisdiction over the consent decree ended? Putting aside the Fourth and Fifth Amendment complaint,
Sure.
What is your position on whether or not those terms of the settlement agreement were all complied with as of that July 22nd date?
Well, first off, there is no settlement agreement because the prior appeal, the Rasho decision, determined that the agreement was a consent decree.
Okay, then what's your position on whether or not the terms of the consent decree were satisfied as of July 22nd?
As of July 22nd, the court's enforcement authority over the consent decree expired.
That's a separate question.
Sure.
Then what is your position on whether or not the terms of the consent decree had been complied with?
The terms of the consent decree had been complied with. The consent decree listed a number of items that the defendants agreed to undertake, and then there was a mechanism by which the court could enforce those provisions. The plaintiffs filed a permanent injunction seeking to enforce certain provisions of or alleging that there was noncompliance with the consent decree, and this court reversed the permanent injunction and held that there were no ongoing that the issues of noncompliance that they raised did not present an issue of federal rights violation, and vacated the permanent injunction. From there, plaintiffs filed additional additional relief in the district court to enforce provisions of the consent decree, but those efforts were denied. The court did not find any ongoing constitutional violations and denied their motions.
You tried the court there, you talked about the district court.
The district court, yes.
So to put some timing on this, Rasho decision comes out January 12th of 22. Mm-hmm. Mandate issues a certain number of days later. Case goes back before the district court, and you're now indicating district court makes no reference that there's any federal rights violations remaining.
For any additional issues that they had raised, that if they had raised issues of noncompliance, the district court did not enter any orders finding that there were that there were instances of substantial noncompliance that rose to the level of a constitutional violation, which is what was required under the consent decree.
Is that a separate order from Judge Mims somewhere between February and July of '22?
Yes, and that addresses their additional issues of noncompliance.
You don't
And
happen
then
to have a date or a docket entry or something like that?
I'll have to pull that up.
How do you explain the July 21st order, returning it to the active docket, saying that the court has operated as though there's no longer an agreement, and returning it to the active docket? That sounds to me like the consent decree has fallen apart, and so we're going to litigate this case.
Well, the consent decree was the final judgment in this case, and it encompassed the entire
What is
lawsuit.
that based on, that it was the final judgment? Because the court entered an order at the very beginning on May 23rd and referred to the consent decree as the settlement agreement and said, this matter will remain on the court's docket until the terms of the settlement agreement are met. At that time, this matter will be dismissed with prejudice. That's when it becomes a final judgment, when it's dismissed with prejudice. And I am confused by the July 21st order saying we're returning to the docket, active docket.
In the interim, the district court entered the permanent injunction, which was appealed to this court in
Correct.
the Rasho decision. And in the Rasho decision, this court determined that the agreement that the parties had entered into was judicially enforceable and was thus a consent decree. The consent decree, by definition, is a final judgment on the merits of the case. And when the
What are you
case went
relying
back,
on for that consent decree being a final judgment in the case?
On this
Because the
court's-
case wasn't, I mean, the court continued to retain jurisdiction to enforce it. And usually you don't have a final judgment until that jurisdiction is relinquished.
Well, under this court's, first off, under the Supreme Court's precedent in the Rufo case, the court acknowledged that the consent decree is a final judgment that may be reopened only to the extent that equity requires. And this court has also, in the Jonesell versus Burge decision and in Bogart v. Wright, expressed that a consent decree is a final judgment on the merits. And of course, the court retains jurisdiction to enforce its judgment. But in this case, the jurisdiction of the district court to enforce the judgment was circumscribed by the terms of the consent decree. It was limited in scope and it was limited in duration. The parties had agreed that the consent decree would expire 3 years after the relevant approval date, and then they had agreed to an extension of that, which gets us to that July 22nd, 2022 date. And so that was the date that the courts, by the terms of the agreement, the court's enforcement jurisdiction ended, and so there was no longer a case or controversy between the parties.
Mr. Hirschman is saying that 40 areas arose after the Rasho appeal was filed. Can you tell us how those 40 areas were somehow resolved before the court let the consent decree expire? It's so confusing.
Well, again, the consent decree was the final judgment in the case, and after this court remanded the case after the permanent injunction, plaintiffs, the consent decree was still ongoing. If there were issues of noncompliance that the plaintiffs wanted to raise, they could seek relief in the district court. But when the court's jurisdiction expired on July 22nd, 2022, there were no outstanding motions or requests for relief. There were no outstanding allegations that there were instances of noncompliance for the court to address. And so the court's jurisdiction ended at that time. At that time, there was no case or controversy between the parties.
Not
To
all,
the extent
not
that-
all courts, though, who deal with this situation of a consent decree which is expiring by its own terms and date. Not all of them use jurisdictional language. Some call it mootness. Some call it authority or relevant authority. The court lost its authority to handle it, or the matter was moot. When terms like judgment or jurisdiction are used, they're very dedicated meanings under our statutes and our rules. And so I think what we're asking you to address, Ms. Hanson, is what happens to the case July 23rd of 2022? Is it moot? Does the court lack authority? Or are you saying it's a dismissal with prejudice and a loss of subject matter jurisdiction?
It's a dismissal with prejudice and a loss of subject matter jurisdiction. And there was no complaint filed until after that July 22nd date. And so the plaintiffs, to the extent that they have...
Don't all the terms of the settlement agreement have to have been met in order for it to be a dismissal with prejudice, as the court said in the May 23rd order?
No, because again, the court's jurisdiction was circumscribed by the agreement. The court's jurisdiction was limited in duration and it was limited in scope. The court could only enforce provisions of the decree to the extent that it found an ongoing federal rights violation and made PLRA findings to that effect. And that did not happen. There were no outstanding issues of if there had been an outstanding motion suggesting that there were ongoing violations and asking the court to resolve those through an order under the dispute resolution provisions of the consent decree, that would be a different case. But here
Doesn't
there were
returning it to the active docket suggest that there were outstanding issues? Why else would you return it to the active docket?
Oh, I'm sorry, I didn't mean to speak over you. There were no outstanding requests for relief. The plaintiffs had no outstanding requests for relief that could be addressed under the court's enforcement authority of the settlement agreement.
It's just so odd. There's this notice of proposed negotiation plans on June 1st of 2022, which some will argue that's the fact that there's some ongoing discussions going on. That doesn't necessarily precurse other amended complaints, but why doesn't the district court say, I'm denying your fourth amended complaint, your fifth amended complaint, because I don't have jurisdiction because consent decree is ended?
Well, as the court said, that was a mistake. That is what it should have done, but it made a mistake. But the court's error, the party's failure to raise it, couldn't affect the court's jurisdiction here. And then the negotiation plan was just that. It was a plan of negotiation while the consent decree was still in effect. The parties agreed to negotiate to work towards a new agreement, which they didn't do. And so that left the entire consent decree intact. I see that I'm out of time. But I would also add that for the reasons set forth in our briefs, then we would, the district court erred in not returning the $1.9 million deferred fee payment.
Give me 1 minute. Judge Rovner, any further questions?
Well, only 1,000, but
Any that you'd like to pose at this time?
I really would like to see Mr. Hirschman again.
Very good. Judge St. Eve?
No, thank you.
Thank you very much, Ms. Hanson. Mr. Hirschman, why don't you come back forward? We'll set 3 minutes for rebuttal, and then let's hear from Judge Rovner first.
Your Honor, could I just read where you can find the areas that weren't resolved? It's at docket 3263 at 2, Exhibit B, and it's discussed in our brief at page 6.
What's the date of that entry, please?
That entry is March 8, 2021.
That predates the Rasho decision.
It predates the Rasho decision, and in the Rasho decision, I can't find the page, but it acknowledges that there are other matters in the district court. So that's point one. Point two, Your Honor pointed to 3580 or A21, the proposed plan of negotiation. and it acknowledges that there are issues about compliance. And then it goes on to say, if we're unable to reach an agreement to resolve those disputes, and this is a court order acknowledging that there are disputes, the parties agree that the matter will be returned to the active trial docket and propose, subject to the approval, that we'll file an amended complaint. So Judge Mim enters an order, Judge Mim follows the order, we follow the order, and now we're told, oh, actually the case was dismissed with prejudice, and if it had been dismissed with prejudice, obviously we would have had appeal rights. And instead, we're told 2 years later, after we're just about to finish discovery and go to trial to address the suffering that we think is happening, and we're told, oops, 2 years ago I made a mistake. That isn't, he didn't make a mistake.
If the parties were engaged in these negotiations that you're describing, and I have no doubt they were, why not just revise the consent decree and try to get approval from the court? Because that had been done previously in the case.
It had been done previously. The letter we received, which is in our brief on the 23rd, we said we had told them that he might not be able to enforce it himself after this court's order, but it still existed. They said, oh, no. We're going to litigate this case. And that's why there was no ability to resolve the issues. We tried.
What about the state's point that there was no pending request for the court to resolve the 40 areas of noncompliance?
We had requested that they resolve the 40 areas of noncompliance. What effectively that means is we had to have a motion pending, and it wouldn't have made any difference because the consent decree was over. So the point is that the areas where there wasn't compliance, the court had determined there wasn't compliance, and there was no time, literally, to effect compliance in the 1 day or actually the mandate of this court came down May 22nd. So we tried to do that, and we failed. And so then the question becomes, are we nowhere? Are we losing our class? Are we losing our ability to move the case forward? And do we then have to file a new case, pay $455, in order to then be faced with, oh, you don't have a class, you don't have a viable complaint, you can't use any of the evidence because it was all for the original case, who knows what, and who knows how long it would take. If this court please sends us back, we can have this case on trial in a year and a half, and we'll know whether they are complying with the Constitution. This isn't just, this is their duty to provide mental health care, and nobody has testified that they are actually providing mental health care. This court said, we think they're on their way, we think they're not, but nobody, the trial judge or us, or the defendants.
Thank you, Mr. Hirschman. Thank you. Thank you. Anything further, Judge Rovner?
No, but thank you very much.
Judge St. Eve? Thank you very much, Mr. Hirschman. Thank you very much, Ms. Hanson. The case will be taken under advisement. We're now going to move to our final case of the day, Appeal 24-1297. This is Ravenhorst versus Mayorkas. We will begin with argument from the appellant by Mr. Smith. Mr. Smith, you may take the lectern.
Councilman and the court, Michael Smith on behalf of the appellant, Carl Ravenhorst. We're here basically on a summary judgment being granted on a suspension that he had, which we believe was wrongful. This particular appellant actually was working for FEMA, but prior to that, he'd been working with the Navy. He was actually on the Navy's Midwest Regional Anti-Terrorism Program Manager, and then Region 5 actually recruited him for the Anti-Terrorism Program Manager called REP, which is the Regional Emergency Preparedness, which is the REP program.
Mr.
Basically-
Smith,
Yeah.
this was, hello. This was a summary judgment. So we can assume that Mr. Ravenhorst is right in asserting he was doing his job correctly. That O'Leary and the others were not complying with FEMA rules and procedures, and that his co-workers in Puerto Rico were incompetent. But what is the evidence that he did not engage in the misconduct he was disciplined for? For example, talking out of school with FEMA contractors, using abusive language, and behaving inappropriately vis-a-vis his co-workers in Puerto Rico. I think that's what we have to zero on in.
Well, to answer that, basically, he was considered with REMA, with the REP program, to be an expert. And then he was assigned out to do the job to protect the country, and that is to going and working with states on being ready for nuclear issues. And that's where the problem started, when he was actually on a site in Michigan, when they had a certification problem there. He was reprimanded because he actually demanded the staff there complete the certification compliance failures. And then in 2017, there was also a problem in Puerto Rico with the Hurricane Maria.
But Mr. Smith, I didn't see anything in the record where you disputed that your client used profanity, complained about his boss to the contractors, contacted state officials directly when he was told not to. I didn't see anything where you're disputing those underlying facts. Is that fair?
Because O'Leary basically didn't have the understanding of the
No, that just, I want to make sure that I'm not missing something.
Okay.
You aren't disputing those underlying facts, correct?
Correct.
Okay.
I mean, what we're saying is that in regards to O'Leary and my client's attempt to get him to comply with the different REP program guidelines, he refused. And so he would get in trouble with insubordination. And that goes to the official letter that he had sent to the one state asking them.
Yeah, you argue that O'Leary was not performing his job. I understand that, but I just want to make sure I didn't miss something in the record with respect to those other facts.
Well, I think we did address the fact that by trying to get O'Leary to understand the REP program, O'Leary refused to listen to him and sometimes even waived requirements under the REP program, which he didn't have authority to do. And because of his working with O'Leary, that's where he started getting reprimands. He got reprimanded by contacting the state, which was not doing anything to comply with their readiness. Because of that, O'Leary gave a waiver to them over the objections of my client. In Puerto Rico, he was assigned to a task of being prepared on Maria, and he was working with some DEI females who didn't understand the program, didn't understand some of the issues that are involved in being prepared. There was some catastrophes where somebody had to decide about having planes ready to bring supplies in, and it didn't happen, and he would complain. Because that, and the facts that there were temporary female workers there, they didn't want him being there, so they argued against him being there, and he got transferred. I think the point is that the retaliation is clear, that based on his trying to make sure the United States is prepared for a nuclear disaster, and that there are people working with FEMA that were totally unqualified, he was trying to do his job from having the naval experience. And he may have been a little gruff, but that comes from his having been in the Navy. I mean, there's a lot of certainly things that occur that somebody who's in an official capacity of a commander, seeing somebody that's not doing their job sometimes blurt something out, which is basically the frustration that somebody has when they don't understand the REP program and being prepared for the country to be protected.
Would you like to reserve the remainder of your time?
Yes, I'd like to reserve my time.
Very good. Thank you,
Thank you
Mr.
for finding
Smith.
out.
We'll now hear argument on behalf of the appellee, Ms. Phillip.
May it please the court, Mr. Smith? Mr. Ravenhorst was not disciplined because he was trying to get the agency to comply with various regulations regarding the radiological emergency preparedness program. FEMA disciplined Mr. Ravenhorst because his supervisors repeatedly told him not to engage in insubordinate, abusive, disrespectful, and disruptive conduct, and he kept doing so. In March of 2016, he was reprimanded because he emailed the Michigan State Attorney General without FEMA's authorization to criticize the interpretation of state law. And in that March 2016 reprimand, he was reminded that he had previously been verbally counseled twice in 2015 and warned for sending exceedingly aggressive and argumentative emails. A year after the March 2016 reprimand, he was reprimanded again for an argument with Ohio Emergency Management Agency officials, where he asked, "Does anyone here speak English?" And when no one responded, he said, "This is bullshit." His misconduct resulted in his removal as a FEMA Ohio site specialist at the Ohio officials' request. 2 months after that, during the Monticello exercise, he told a contractor that his supervisor, Mr. O'Leary, had his head up his ass, and then he continued to complain about O'Leary's decisions relating to the Monticello exercise after being instructed via email and text that he wasn't authorized to speak with the contractors and to bring his complaints to his FEMA chain of command. In October of 2017, during the Puerto Rico deployment, he caused disruptions during meetings. He used profanity, yelled at colleagues, lost his temper with colleagues, and told one younger female supervisor, "I have paddled the butts of daughters older than another younger female colleague." And this resulted in the chief of staff of the Puerto Rico mission, Josie Arcurio, releasing him from the Puerto Rico mission.
Let's talk about that mission. That situation seemed to deteriorate a lot at that time and place. What accounts for that deterioration if it's not age issues, sex issues? Interested in your thoughts on that.
Well, I think that in this case that Mr. Ravenhorst was uncomfortable working with or reporting to younger female employees, and that resulted in some friction in the workplace. And also, there's no evidence in the record that Mr. Ravenhorst has presented showing that any of the younger female employees that he claims were incompetent had any bias against older men. There's no comments or declarations from any employee saying that there was a bias against men. And also, Arcurio, who was the chief of staff, who released him because of his conduct there's no evidence that she had a bias against men or older workers, because there's the only thing that Mr. Ravenhorst points to is the fact that he says that she was a man-hater. But there's no evidence in the record from any other employee in terms of declarations or documents where she's making comments that show that she's a man-hater. This is just his personal subjective belief.
To the extent we're looking for some type of objective factors, a lot of those complaints happen within a short period of time, but from different people.
Correct.
So that could be read one of two ways, right?
It could be, but when Mr. Ravenhorst was asked about the events, there's no dispute that he made the comments about paddling the butts of daughters older than younger female colleagues, and then he made those comments. And the disputes about how the Air Operations Branch was running in the Puerto Rico mission, he wasn't disciplined because of any competence issues. He was disciplined specifically about his conduct, and there's no dispute that his conduct was abusive, disrespectful, and disruptive.
There's no question about his performance at all, right? I know there's the question about the conduct, but the actual job performance, he was good at it seems like, based on what's in the record.
Correct. The job performance was good, but whether an employee is meeting the employer's legitimate expectations is not limited solely to the job performance. The civility and decorum, camaraderie in the workplace is also part of the employer's legitimate expectations. And here he was repeatedly counseled, warned, and then reprimanded for engaging in behavior that was not meeting that part of the expectations. For example, in the written reprimands that he received, he was admonished that he was expected to act in a manner that did not reflect negatively on the agency and the federal government, and that he was expected to exercise courtesy and professionalism in his dealings with co-workers, supervisors, and the public. And so this conduct for which he's being reprimanded is not meeting those standards. And based on, FEMA's role is to collaborate with the local officials to prepare and respond to emergencies, and it can't do that if an employee is being removed at the request of the local partner because of his conduct. There's no reasonable fact finder could conclude on these facts that Mr. Ravenhorst was meeting his employer's legitimate expectations. There's also no evidence in the record.
It's the second element of McDonnell Douglas, correct?
Correct. There's also no evidence. Mr. Ravenhorst has not presented any evidence of a discriminatory or retaliatory motive for any of the employment decisions that were made. He was disciplined because of his conduct, and there's no dispute about that, and he has not presented any evidence showing that these employment decisions were made because of his age or his sex or his protected activity. He does point to he makes the statement that the co-workers and the chief of staff in Puerto Rico had animus against men, but really that's just his personal subjective belief. There's no evidence of that. He hasn't presented any evidence that Mr. O'Leary, the deciding official for the suspension, also had any discriminatory or bias against men either. He points to a November 2017 email that was sent that he says shows that Arcurio, the chief of staff, and O'Leary, his supervisor, had knowledge of his protected activity. But by the time that email was sent, he had already been released from the Puerto Rico mission, so that could not have influenced Arcurio's decision to release him. And also, the supervisor, Mr. O'Leary, had already begun the process of disciplining him in connection with the Monticello exercise in September of 2017 when he contacted an HR specialist. There's also no evidence that Mr. Ravenhorst has presented that showed that similarly situated employees outside of his protected class were treated more favorably.
This is the fourth element of McDonnell Douglas.
Correct. He points to certain female co-workers in Puerto Rico that he claims were incompetent, but he doesn't show that they have engaged in any of the insubordinate or disrespectful conduct that he did or had a similar disciplinary history. And he hasn't identified any employee out of his class who was treated differently. And finally, he has failed to present any evidence from which a reasonable fact finder could conclude that he was subjected to a hostile work environment. The types of events that he's describing don't show a workplace permeated with discriminatory ridicule, intimidation, and insult. The events that occurred in Puerto Rico, there's no evidence that any of those things happened because of his protected class, his age, or his sex, or his protected activity had not yet occurred at that time. And he does point to some events that his supervisor, O'Leary, rescheduled meetings or changed his work schedule. But the reasons that were provided, but O'Leary provided reasons for those changes to his work schedule, not missing meetings, and those had nothing to do with his age, sex, or protected status. So on these facts, a reasonable fact finder could not return a verdict in his favor on his discrimination and retaliation claims. Unless the court has any further questions, we ask the court to affirm the decision of the district court.
Thank you, Ms. Phillip. Mr. Smith, we'll move back to you now for rebuttal argument. And Mr. Smith, I'd like you to focus you in on those second and fourth elements of McDonnell Douglas, meeting legitimate job expectations and comparator.
Yes, Judge. Well, basically, again, my client was doing his job. He had a job description that was given to him by FEMA. Basically, he was doing his job. His job was to protect the country. His job was to make sure that state officials were abiding by the REP program to protect the individual citizens in each of their states. He did it. He did his job. Also, the fact is that the job description is also modified by the fact that he actually is prescribed to do his job by federal statutes, regulations, and policies. I think at this point he did his job, and sometimes people don't care about following the rules, like O'Leary didn't care about following the rules. And also O'Leary, by the fact that he didn't follow the rules, he had no disciplinary actions taken against him. As far as the comparable, there were several women that were identified that didn't do their job. He was called in to rectify and try to correct some of the things that were going on. So I think the big thing was O'Leary wasn't doing his job to protect the country by waiving requirements on the preparedness. The females were not doing their job, and they didn't get reprimanded either, where he's called in to help correct the problems to protect Puerto Rico. I think the facts speak well in our statement of facts that he was doing what he's supposed to do. They didn't like that he did what he's supposed to do, and not everybody who works with somebody wants them to abide by the rules, and that's the case here. I think we actually presented a good case of retaliation because he's trying to get O'Leary to do his job. He's making him understand, and O'Leary doesn't want to do it. And based on that, he starts writing him up. They then find different reasons to put small things together and call it conduct. But the conduct is based on somebody not doing their job. It's not somebody just getting up and saying, I don't like you, you're doing a stupid job. He's trying to get people in line. He's trying to get them to respect the law.
Thank you, Mr. Smith. Thank you, Ms. Phillip. The case will be taken under advisement. That completes our arguments for the day. Of course, the court will be in recess.